I did find the section of the regulations, so we can kind of go into that.
Sure.
USCIS published a final rule for H-1B regulations, and this has been a long time coming. It's taken the administration just a very, very long time to publish it, and now that they have, it's going to be taking effect on January 17th, which is only 3 days before the new administration enters office. The timing is definitely pretty crazy on that. The new regulation is pretty reasonable. I don't have any major complaints with it, and it does actually open up some new and exciting opportunities, especially for entrepreneurs. I'll put out a full write-up of the regulation and how it changes H-1B and all of that later on this month, just before January. But for now, the key provision is that USCIS has officially put it in the regulations that people who own a majority share in their own company can sponsor their own H-1Bs. Or they use the company to sponsor the H-1B. But essentially, this provision on self-employed H-1B sponsorship has been lifted, which is very, very good. USCIS says that they've put certain requirements and restrictions on this, which is true, but the restrictions are actually pretty reasonable. The first major change is that if the person owns a majority share in the company can only sponsor them for 18 months, not for 3 years. Part of that is because USCIS knows that a lot of startups are going to be doing this kind of sponsorship. And if a startup fails quickly, like say the startup fails within the first 6 months, USCIS doesn't want a full 3 years on the record. They do the same kind of thing with L1 visas, where they do a new office L, which is actually only valid for about a year. And so they're kind of copying that format over to the H-1B format as well. 18 months is going to be the first period of approval. And then at the end of that 18 months, the company will need to prove that they're still in business and that they can still pay their founder and their owner's wage in order to get the extension. So it's fair. It's a little different, but it seems fair. They also said that the employer owner needs to be involved in a specialty occupation. This might seem obvious or go without saying, but it matters a lot because I know a lot of people in the US who want to get H-1B sponsorship through their company, but they really do just want to be an owner, where they're making the major business decisions, taking in the profit, but not really involved in the day-to-day operations of the business. You are allowed to be an owner and still have a different employer sponsor as long as you're not actually working for the company. So, technically that's already allowed. USCIS just wants to make sure that they're not in a situation where a bunch of people are self-sponsoring and then are basically MIA, where they're not really doing anything for the US. They're not contributing skills or expertise. The H-1B is not supposed to be an investment visa. The H-1B is a visa for people who are performing in a specialty occupation and really filling in a skills gap in the US. So the owner needs to be performing a majority of tasks that are related to their specialty occupation. This means that founders who are coming out of a project that they developed, like software engineers who developed a particular solution, will be really well set up under this provision. But if you are working in tech and you want to go purchase an ice cream store and own it, it's not going to work under H-1B because number one, you can't just be the owner and sponsor yourself for H-1B. And then number two, even if you were doing the work involved for the ice cream store, it's not a specialty occupation. So just keep in mind there's restrictions. It's not opening up necessarily a new immigration pathway, but it's a really positive development and will really, I think, benefit the state of immigrant entrepreneurship in the United States.
So under these new regulations, would it be possible to work for an employer and also start your own company and then sponsor yourself through that company?
Yeah, I would expect to see a lot more concurrent H-1Bs filed, especially if the company is only just starting to get off the ground or if it's like an idea that's still in development. You could have your full-time job and be sponsored through a normal 9-to-5 company, and then do a concurrent part-time H-1B and be sponsored through your own company. Keep in mind, though, like if you're sponsored through your own company, you do have to pay yourself the required wage. A lot of really, really early stage startups aren't really at that point. So, again, it doesn't open up this option for everybody. But say you have a little bit of angel investment funding or family and friends funding, you have a really strong idea and you want to really build that up, you can start doing that by doing a concurrent H-1B.
So let's say you're a software engineer at a FANG, and then you have this idea for like an AI startup. You could start that startup while working and then sponsor yourself through that startup, even if it's your own funds.
I mean, there's no prohibition on that. I will say I would expect this to be kind of questioned and fleshed out as we see more and more of these petitions filed. I would think that if it's a clear situation where the person is just setting up their own company, funding it, and sponsoring themselves for H-1B to stay in the U.S. without really building the company, like there will be a bunch of sketchy situations like that. Like it's just inevitable. There will be those kinds of situations, and USCIS is not going to accept those. So I would be very, very skeptical. But if you are starting a legit AI company and you want to bootstrap it and self-fund it for a while, that's fine. You can totally do that. Now, keep in mind that as a founder, you don't always need concurrent H-1B authorization to do some of the really early stage work. And again, I shouldn't say work. Everyone says work. You shouldn't need it to do like the ideation, coming up with the idea. Maybe a few basic programming things to come up with a sketch of what the solution would be. You probably do, though, need to have work authorization if you want to do outreach to customers, if you want to actually put something out on the market, if you want to receive any kind of revenue, compensation, anything like that. That's when you need the protection of work authorization, because all of that is mostly considered work in the United States, even if it's for an early stage startup. But I mean, if you are just literally sitting in your basement on massive array of computers and coming up with something on your own, you don't necessarily need work authorization for that stage of like the super early startup ideation portion. So yeah, it's still worth talking to an attorney, seeing what you need, seeing what makes sense for your stage of development. But this at least opens it up significantly, where you can be in charge of an entity that is actually putting a product out there, maybe receiving a bit of compensation and revenue, receiving funding, like acting as a business. You just need to make sure that it's approved. And then in the first 18 months, you need to make sure that the business is actually becoming operational.
So, isn't this pretty much like an old... So all these people who are trying to get H-1B right now and are in their last or second last chance, they're all looking at O1 or CPT.
Mm-hmm.
Isn't this now like a third option for them where they could literally...
Unfortunately not. So it is still lottery based, unfortunately. So it's not cap exempt like some of the other categories. I guess you could potentially start a nonprofit research organization and get a cap exempt H-1B through that. But that would be very, very complicated, especially for an early stage startup. Like you would need significant grants and funds and all of that in order to make that work. Because instead of submitting a business plan, you would be submitting a plan that shows how your money is going to be allocated to certain research activities. The vast majority of these cases are still going to be lottery based. And so in March, you will need to make sure you have a legal entity like an LLC or a C Corp, an S Corp. No, I guess the S Corp is usually an LLC. But you need a legal entity, and then you need an FEIN number from the IRS. You need to use all of that to submit your name in the H-1B lottery and then see if you can sponsor yourself. The situation with the concurrent H is a little bit different because a concurrent H does not need to go through the H-1B lottery. But you can't do a concurrent H and then ditch your 9-to-5 job because they go together. So if you want to start your startup while working for your 9-to-5, that's great. But you will need a plan for what happens when you actually want to quit your job and start full-time at your entity.
So regardless, you only get one chance every time, regardless of how many H-1Bs you have?
So, I'm going to say something, and I don't want people to take it in a sketchy way. You can still get multiple employer sponsors in the lottery. I know there's a misconception that a lot of people are saying you can't do that, but you can. Now, they're running the lottery. They're now running the lottery more on a per person basis, less on a per company basis. So it's not like you're necessarily building your chances. But if you want your startup to submit your name in the lottery and your 9-to-5 job to submit you in the lottery, go ahead and do both. And that just gives you options for which one is going to be the main official sponsor by the time you can file your H-1B petition, and then when October rolls around, you can start working for whatever that entity is full time. You can also do concurrent employment. So say you really want to work for your startup, but you are fine with settling for a 9-to-5 job, have your 9-to-5 employer sponsor you, and then if that's the one that's selected, you can still work part-time for your startup. You just have to make sure that it is part-time because you have to fulfill your full-time obligations to the full-time sponsor.
So Automatic has a question, but just one last thing. So all these people are trying to look into CPT in 01. Can't they just technically start their own company and then enter themselves into the H-1B lottery?
That is now becoming an option, yes. It is something to consider.
That's a huge development for a lot of tech people.
Yes, I would say yes, it is a huge development. I don't want people taking it, though, to mean that they will get the H-1B, because lottery chances are still 30 to 40%. Right. So, I mean, you need a backup option.
Like some of these people are in a situation where their company's unwilling to enter them into the...
Right. Or some people on STEM OPT are truly working full-time for their own startup company, and they need to job search for a 9-to-5, and it's getting in the way of what they're doing. And they need to search for that 9-to-5 because they need H-1B sponsorship. So being able to set all of that aside and not get distracted and still go all in on your business is a huge benefit. I definitely don't want to minimize that or take that away. But just remember, you do need the lottery. You do need a backup plan if you don't get the lottery. This isn't a magic bullet. It's just a really positive development.
Right. But technically, if your employer is not willing to enter you into the lottery, this is your way into the lottery.
Yeah, for sure. I think it's going to be easier for people who are further along, though, in the establishment of their startup.
Right.
Probably wouldn't recommend that if someone is having a really hard time getting the lottery or getting sponsorship, that they just come up with a business idea and try to do it on their own. Right. When you submit these kinds of petitions, you will be required to submit a business plan that shows the trajectory of your company. You'll be required to prove that you can actually pay the wage, that the company will be doing something. And, at the end of 18 months, I would expect some increased scrutiny. That's what happens in the L1s. Usually after you do an entrepreneur L1 or a new office L1, you get a year. And at the end of that year, when you file the extension, they almost always give a site visit, like an in-person visit to just check up on the business operations and make sure that they're legit. I would expect similar kinds of enforcement actions for this new H-1B. And so if you are a brand new entrepreneur without any support and you're just kind of doing this to stay in the US, build that support. Get that support, make sure that you are going to be successful. Because if you're not, and if your business fails in the first 6 months, you shouldn't be staying here on the US in H-1B status after the business fails. You would need at that point to leave, or you would need a different kind of backup option. So there's a lot to think through and work with, but for people who are really serious about entrepreneurship, this is a big development. And I would expect, I think, a lot of businesses now, and a lot of new businesses to sponsor their founders or owners in the lottery in March.